Good morning. This is Judge Stanley speaking. It looks like we have everybody in the hearing. So let's go ahead and start the live stream. Okay, just a few preliminary comments. Since we are in a virtual hearing, it's important that you mute your microphones when you're not speaking to avoid feedback, and that when you speak each time, please state your name first so that our stenographer, Ms. Alonso, can determine who's speaking, since she's not in the same room that as easily. I am Judge Stanley. Welcome to the Office of Tax Appeals. And this case is being heard under the small case program, which means that a single judge will be hearing and deciding the case. We have with us, as I said, our stenographer, Ms. Alonso. She's reporting the hearing verbatim. So to ensure that we have an accurate record, we ask that each person state their name when they speak one at a time, and avoid speaking over one another. Speak clearly, slowly, and loudly enough for her to hear you. When needed, she or I may interject to ensure proper transcription. After the hearing, Ms. Alonso will produce the official hearing script, which will be available on the Office of Tax Appeals website. So unless anybody has any questions at this point, let's go on the record. This is the matter of the appeal of Pear LLC, OTA case number 24031562. The date is August 21st, 2024, and the time is 10:15 a.m. I'm Judge Teresa Stanley, who will be the single judge hearing this appeal under the procedures of the Office of Tax Appeals Small Case Program. I'm going to ask the parties to identify themselves for the record and who they represent, if anyone, starting with the appellant. Mr. Roberts.
Oh, sorry. You said the pilot?
Appellant, I'm sorry.
Got it. Sorry. Yeah, my name is Matthew Roberts. I started Pear LLC.
Okay, and Franchise Tax Board.
Good morning. This is Leo Cristobal representing respondent Franchise Tax Board.
Ms. Brosterhouse, you have we could barely hear any noise, any sound coming from your mic.
Okay, let me try it again. A little better?
Yes.
Okay.
Okay, so what Ms. Brosterhouse did, her own name, Maria Brosterhouse, for the record. So the issue today, excuse me. The issue today, as stated in the minutes and orders, are whether appellant has established reasonable cause to abate the late filing penalties for taxable years 2019 and 2020, and whether appellant has established reasonable cause to abate the late payment penalty for taxable year 2021. Mr. Roberts, do you agree that that's the issue?
Yes.
And Mr. Cristobal?
Yes, this is Leo Cristobal. I agree. Those are the issues.
This is Judge Stanley speaking again. Thank you. For exhibits, appellant submitted exhibits 1 through 3, which includes denials of claims for refund for the 3 taxable years at issue. The Franchise Tax Board did not object to those exhibits, and they are admitted into evidence. The Franchise Tax Board submitted exhibits A through H. Appellant did not object to those exhibits, and those exhibits are also admitted into evidence. So we're going to begin with the appellant's presentation, and I need to place Mr. Roberts under oath so that we can consider any statements he makes as evidence in this matter. Witnesses remain under oath until the close of the hearing. So, Mr. Roberts, I'm going to ask you to raise your right hand, please. Do you swear or affirm that you will tell the truth, the whole truth, and nothing but the truth?
I do, yes.
Thank you. You requested, this is Judge Stanley speaking. Mr. Roberts, you requested 5 minutes at the pre-hearing conference, and I believe I said I would give you 10 minutes, but did not include that in my minutes and orders. You may take up to 10 minutes if you need to do so. So you can proceed when you're ready.
Okay, thank you very much, Judge Stanley. This is Matthew Roberts speaking. So when we started Pear LLC, we were under the impression that we didn't have to file tax returns unless we made over a certain amount, $10,000 per year, or turned a profit. We never did either of those things. We ran Pear, which stands for Positive Engagement and Response, more like a nonprofit than a business, as we donated our time to elementary schools, junior high schools, prisons, mental health facilities, to share our new positive conversation-based card game. We created the LLC to legitimize us so that we could work with schools and mental health companies, which we donated $1 from each sale of our box of cards to Mental Health America, American Foundation for Suicide Prevention, and other charitable organizations. And we paid the $800 yearly fee.
Mr. Matthews, can I please, I'm sorry, Mr. Roberts, may I please slow you down just a little bit?
Yes, sorry.
Thank you.
This is Matthew Roberts speaking again. We paid the $800 yearly fee in California to keep it in good standing each and every year in which we operated, which was around 2017 to about 2020. When COVID hit, it impacted our ability to go into these facilities. So we did not pursue this any further. When we decided to shut down Pear is when we found out that we needed to close down our LLC. So we hired somebody to come in and file the necessary paperwork. This is when we then went to close out our bank accounts with Chase, which is when we saw the COAL coal levy for the amount of $3,110.27. This was on June 15th of 2023. This was a shock to us as we had never received any sort of documentation or notice from the Franchise Tax Board, and therefore had no idea that we were late or had outstanding penalty fees.
Mr. Roberts, I'm sorry to interrupt. You sped up again. So just please slow down a little.
Would you like me to go back a little bit?
No, she's the stenographer is indicating that she did catch what you said.
Okay, thank you. Again, this is Matthew Roberts speaking. We had never received documentation or notice from the Franchise Tax Board, so we did not know that we had late or outstanding fees. We then filed a request for an abatement of the penalty, which was in the tens of thousands of dollars for the tax years of 2019, 2020, 2021. We also had a similar issue with the IRS when we had found out and started to close the accounts down, in which we sent back a very similar story or request, mentioning of the lack of understanding about filing, as well as the lack of notices that were sent to the parties involved, myself and two co-founders, in which they then waived the late fees and the accruing interest for Pear. This $3,110 was again taken from the coal levy from our bank account, and this was essentially our break-even project with Pear. That again was a passion project to really better society through helping the youth communicate stronger and sharing this with the education system and mental health programs of our communities in Northern California. I guess that is essentially the story and what we're hoping to receive back. I don't have anything else further to share.
This is Judge Stanley speaking. Thank you, Mr. Roberts. Mr. Cristobal, does the Franchise Tax Board have any questions for Mr. Roberts?
This is Leo Cristobal. Franchise Tax Board does not have any questions at this time.
Okay, this is Judge Stanley speaking. I do not have any questions for Mr. Roberts at this time either. So we're going to move to the Franchise Tax Board and their presentation. Mr. Cristobal, you requested 10 minutes and you may proceed when ready.
Thanks, Judge Stanley. Good morning. My name is Leo Cristobal, and I represent Respondent Franchise Tax Board. This appeal involves the per partner late filing penalty and the late payment penalty. As has been mentioned, the issues being considered are appellant not meeting its burden of proof to show reasonable cause for filing its 2019 and 2020 tax returns late, and appellant not meeting its burden of proof to show reasonable cause for making its 2021 tax payment late. Appellant is an LLC. Appellant filed its 2019 return 21 months after the due date, filed its 2020 return 13 months after the due date, and paid its tax due for 2021 27 months after the due date. When an LLC fails to timely file its return, FTB is required to impose a per member late filing penalty. And when an LLC fails to timely pay its tax, FTB is required to impose a late payment penalty. When FTB imposes these penalties, the law presumes the penalties were imposed correctly. To overcome this presumption, California law requires the taxpayer to establish that its failure to file or pay timely was due to reasonable cause and not due to willful neglect. And ultimately, the taxpayer has the burden of proof to show that reasonable cause exists, and unsupported assertions are not sufficient to satisfy a taxpayer's burden of proof. So here, appellant contends in its briefings that, partly due to the COVID-19 pandemic disrupting its operations, that it was unaware it had a filing obligation until it decided to close. Importantly, even if a taxpayer is unaware of a filing requirement, it is well-established law that ignorance of the law is not an excuse for failing to file a timely return. Additionally, to date, appellant has not provided evidence showing that despite its own best efforts, it was prevented from meeting its tax compliance deadlines, other than generally citing to the pandemic and submitting that it was unaware it had tax compliance requirements to begin with. Appellant has not demonstrated diligent actions or attempts to comply across the 27, 13, and 27-month stretches that spanned between appellant's deadlines to file or pay and the dates appellant's returns or payment were actually filed or paid. Appellant contends, it immediately attempted to come into compliance once it became aware of its tax obligations Unfortunately, although a good faith attempt to remedy compliance issues may lend credibility to a taxpayer's assertions, good faith alone does not establish ordinary business care and prudence. Therefore, the evidence remains insufficient to demonstrate that appellant exercised the kind of care and prudence required to find reasonable cause. In conclusion, because appellant has not met its burden of proof and has not established that its failures to timely file and timely pay were due to reasonable cause, appellant is not entitled to penalty abatement under the law. Accordingly, FTB's action denying the refund claim should be sustained. Thank you, and happy to answer any questions you may have.
This is Judge Stanley speaking. I do not have any questions, Mr. Cristobal. I'm going to turn it back to Mr. Roberts to have the final say and to rebut anything that the Franchise Tax Board may have said if he chooses to do so.
This is Matthew Roberts speaking. I do not have any questions for Mr. Cristobal.
If you have any responses to anything that he said, you can make those responses and have the final say.
I don't, this is Matthew Roberts speaking. Believe I have any responses. That is essentially the story. I guess the one question would be, what is the difference between the forgiveness for the explanation from the IRS compared to the lack of from the California Franchise Board, Tax Board?
Well, let me, this is Judge Stanley speaking. Let me ask you a question, Mr. Roberts. We do not have anything in our file that reflects abatement of any IRS penalty. Are you saying that the IRS did abate a penalty for Pear LLC?
Yes, this is Matthew Roberts speaking. Yes, for the tax years of 2019, 2020, 2021, when we found out the information of needing to file because of looking into our bank account, seeing the coal levy, we had submitted similar abatement documentation to the IRS as we did to the California Franchise Tax Board. The IRS ones were forgiven. The California Franchise Tax Boards were not, which is why we're speaking.
This is Judge Stanley speaking. Do you have anything that shows the basis for that abatement?
This is Matthew Roberts speaking. By that question, do you mean, do I have documentation from the IRS saying that it is cleared?
This is Judge Stanley speaking. Yes. Do you have that documentation? Do you have a letter from them or anything that would show the reason for the abatement?
This is Matthew Roberts speaking. Yes, I do.
This is Judge Stanley speaking. Would you like me to hold the record open so that you can submit that for consideration?
This is Matthew Roberts speaking. If possible, yes.
Okay, this is Judge Stanley speaking. Mr. Cristobal, do you have any objection to holding the record open to obtain documentation regarding the IRS abatement?
This is Leo Cristobal. No objection.
This is Judge Stanley speaking. Mr. Cristobal, also, would the Franchise Tax Board have access to a transcript that would show the reason for the abatement?
This is Leo Cristobal. Franchise Tax Board would typically have access to that information. Also, I think at this point, we would, since we're talking about it, I would ask if Mr. Roberts is able to share share what the reason is indicated on the, obviously we would have to wait for the actual record, but if Mr. Roberts wants to share what the reason, if any, is indicated on the letter from the IRS.
This is
This
Matthew
is Judge
Roberts.
Stan. Okay, go ahead, Mr. Robert.
This is Matthew Roberts. Apologies, Judge Stanley. To my impression, it was essentially negligence of similar to the conversation here, but I don't want to speak exactly for it. It's in a file cabinet that I need to look through.
Okay, I think what I will do in this case is hold the record open so that Mr. Roberts can submit what he has. And then I'll allow 30 days after that's received for the Franchise Tax Board to respond to whatever Mr. Roberts submits. How long do you think, Mr. Roberts, you would need to get any documentation to us? There would be at least 3 for the 3 different tax years, I assume.
This is Matthew Roberts. I can send that over within the next few hours.
Okay, well, why don't I give you 2 weeks just to give you a time cushion, and Franchise Tax Board's 30 days would just start from whenever we acknowledge receipt of your documentation.
This is
Okay, Mr. Roberts, do you have anything further to present?
This is Matthew Roberts speaking. The only question is how to submit. I'm not sure if that's something that we'll follow up with, but yeah, I can submit it as early as by the end of today.
This is Judge Stanley speaking. If you look at your minutes and orders, we have all the different ways to submit documentation to us listed in those minutes and orders. So we have an email address, a mailing address, fax number. So however you choose to do that, you can get all the information from the minutes and orders.
Thank you.
Okay. I want to say, first of all, I missed an important part of my statement, my opening statement that is, I think it's important for Mr. Roberts and for the public who views this to understand that the Office of Tax Appeals is not a court. It's not a court. It's an independent agency that is not in any way affiliated with the Franchise Tax Board or any other tax agency. OTA is staffed with tax experts. The only information that can be considered is what is included in OTA's record. So that is why I'm requesting the additional documentation, since it was brought up and deserves consideration before final opinion comes out. So we will hold the record open for 2 weeks and allow Mr. Roberts to submit the additional evidence. And then the Franchise Tax Board will have 30 days after that to file a response. And at that point, the record will be closed and you'll receive a letter indicating the record is now closed. Within 100 days of closing the record, the Office of Tax Appeals will issue a written opinion. Today's hearing in the appeal of Pear LLC is now concluded, and this is the last hearing of the day, so the hearing is adjourned. Thank you all for participating and enjoy the rest of your day.